Hi, welcome to the Great Legal Minds series. I'm Marcine Seed, chapter of the INBLF Silicon Valley chapter. Today we have a very exciting presentation which covers criminal international investigations and transnational proceedings. We have three amazing panelists today. We'll start with Leo Adler, who has a practice in Canada since 1975 in criminal, quasi-criminal, and regulatory law through Canada. Very exciting. He represents clients in and out of Canada who face extradition, mutual legal assistance issues, interpol warrants, and other international criminal cases. He has many accolades and was even appointed in 2005 to 2015 by the federal government to a roundtable dealing with national security and terrorism issues, including briefings by CSIS, RCMP, and CBSA, and others. You can find out more information from him from the website. Our next speaker is Mr. Kevin Steele out of Hong Kong, working for Robertson's. He is a criminal law specialist who has practiced criminal law, including fraud, financial crime, and defense cases for individuals and corporations in Hong Kong for the last 28 years. He's an amazing criminal law attorney who is recommended in the corporate crime section for the Asian Pacific Legal 500 for Hong Kong. He's probably considered one of the most prominent criminal law attorneys in the area of the Asian Pacific. And then we have our own Sam Rabin from our INBLF Florida chapter. He's an experienced and legal criminal defense attorney who's gained a reputation for his really aggressive preparation and defense for those charged with federal and state criminal crimes. He began his career as a prosecutor and even served under the late Attorney General Janet Reno. And he has a very prominent practice in Florida and is known as the 100 best criminal lawyers in the USA. So welcome to our panelists. And I'm going to throw the stage over to them to give a presentation that'll be most informative for the viewers. Thank you so much.
Thank you very much for that introduction. So this morning, we are going to try and tackle some of the mechanics of international extradition. And as you heard, we have two speakers on the subject who really are in the midst of a dramatic international events. Leo Adler in Canada, and of course you all know that there's this international extradition case going on with a Chinese citizen who landed in Canada on her way somewhere else, who the United States is trying to extradite. And then there are some very fast-moving events in Hong Kong that are hours old. And so I'm going to start off with Kevin Steele. Kevin, what's happened in the last 20 hours or so in Hong Kong?
Well, my presentation can last about 2 seconds because we live in very interesting times. Just last night, in fact, 20 hours ago of our calculation, there's a tweet from the US indicating that they would terminate or suspend the extradition treaty with Hong Kong. The main purpose of extradition, of course, is to ensure people can't evade the criminal justice system by getting on an aeroplane. It's understandable that people are concerned about any justice system and as to whether there can be fair enforcement, proper checks and balances. There's been a lot of press in relation to the national security law imposed in Hong Kong. It remains to be seen how it will play out and what will actually occur. At present, I'm deeply involved in that with the case. A lot of people have at the forefront of their mind political issues. This has to be weighed hand in hand against criminal abuse and lack of cooperation. There are risks that politicians take if they make rash decisions. I'm of the view myself that it's not appropriate for me to express any political opinions. As far as I'm concerned, the taxi rank applies. I will act for anyone who retains me in my capacity as a criminal lawyer, and I must discharge my duty to the client as well as an officer of the court. And that court's the Hong Kong Special Administrative Region of China. And I must do so in accordance with the law. I think in the fullness of time, we will see if the steps to terminate or suspend extradition between the US and the Hong Kong HKSAR are justified. That's my start.
Okay. Leo, there's somebody in Canada that the United States wants to extradite. Did they get notice before they were arrested?
No. The answer is usually no. And one of the interesting things is that, of course, what's made extradition such a hot topic is the involvement of China. In this case, in Canada, the daughter, the founder of Huawei, who was stopping off in Vancouver on a flight from China to somewhere in South America, I believe. And the Americans had put in a request for her extradition. So that's the way most extradition cases begin. You're grabbed, you have no idea about it, and you find yourself brought to court. One of the advantages, however, if you do suspect, and there are, we're getting terrible background, or at least I.
Somebody's got like a TV on or a radio or something, it sounds like.
Anyway, one of the advantages, however, if you are leaving for a place like Canada, because you suspect that some other country where you are is going to look for you, certainly it's to your advantage to retain counsel who then, if they're familiar with the extradition process, can approach the Justice Department in Canada, extradition branch, and you can tell them, look, so-and-so, if he's wanted or she's wanted, speak to me, we'll surrender, because that's the beginning of the process. You've got to be arrested. You have to be arrested, obviously, for what's called a double criminality offense. And there are certain...
When you say double criminality, it means it has to be in both countries?
Means the conduct. It doesn't have to be named the same, but the conduct has to be criminal. So as a classic example, I'm acting for somebody who's a business manager for prostitutes. Prostitution happens to be legal in Canada. It's illegal in the United States, except in parts of Nevada. And so the question of double criminality. It also arose in the Mang case because the United States claims that she committed fraud while telling banks that they didn't have any dealings with Iran at the time that there were sanctions against Iran. Sanctions that didn't exist in Canada. So they lost on that because the fraud was the conduct, and it made no difference that the Americans had the extra aspect of sanctions. So there are requirements, but then you go to have a bail hearing. You then have to go through the process. One of the best things, obviously, and one of the advantages of the INBLF is to approach a member in a state or a country that wants your client and say to them, can you get me more information, or can you put me in touch with the prosecutors? Because there's a lot that we as defense counsel can do on a very practical aspect to assist clients, at least who are in Canada, wanted somewhere else, to resolve the matter or to at least work out some way to try and defend you.
Kevin, Leo just talked about a bail hearing in an extradition matter. in the United States, the prosecutors are directed to oppose bail for that are being extradited to another country. Is there bail in Hong Kong for somebody that's extradition treaty?
Actually, the presumption is against bail in Hong Kong. And I think we follow quite closely the English system, unless there's special circumstances. There are arguments which can be mounted, constitutional arguments, because Hong Kong has a Bill of Rights ordinance. So if you can show special circumstances, then there's a possibility that you can apply for bail. But it's very fact sensitive. But the major issue, of course, in Hong Kong being, as everybody knows, an island near water, is the problem of flight risk, really. So that's the major issue. If there's absolutely no danger of flight risk and someone's got extremely strong ties with Hong Kong, then there is a possibility an application can be made. But generally, if it is a person who has no strong ties with Hong Kong, objection will be made to the bill.
Leo, the United States wants to extradite a citizen that's in Canada. How much detail do they have to give the Canadian authorities about their case in order to get the extradition request granted?
Well, unfortunately, 20 years ago, we amended our Extradition Act, and all you need is a certification by a prosecutor that the evidence is available and that, in his or her opinion, it is sufficient to commit for trial. For those who practice criminal law, preliminary inquiry standard is very, very low. It's just, is there some evidence on which the jury could convict? Not that they would, not that they have to go beyond a reasonable doubt. And so we have what's called the record of the case. And that's a huge issue here, because invariably it's just the froth, if you will, made up by the prosecutor, which is why one of the things that I try to do, and I've approached some of our other members at the INBLF, is can I get some kind of disclosure? Can I find out more in order to try to show that, in fact, there isn't sufficient evidence? It's very, very difficult. We don't have the right of cross-examination. We don't have the right of disclosure and discovery. And it becomes really trying to fit something into a very, very small hole. Unlike, for example, in England or maybe Hong Kong.
So
yeah, in Hong Kong,
in the United
sorry,
States,
you go ahead first.
I was just going to say, in the United States, we really can't challenge the facts in the extradition request. All we really can do is challenge the lack of detail, if you will, and oftentimes that leads to prosecutors supplementing it with additional detail. But we really can't, like you say, cross-examine. We can't challenge the quality of the evidence. What about in Hong Kong, Kevin?
Well, the thing is, a very serious filtering process goes through the Department of Justice in Hong Kong before arrest will be made, before any action is taken. If action is taken, they then need the permission of the chief executive. So the legal requirements are quite strict. The Department of Justice assess whether the minimum legal and evidentiary thresholds are met before authorizing any arrest. And basically what's got to be shown is that there's an extraditable offence under what we call the Fugitive Offenders Ordinance. We have an ordinance rather than a statute. It's got to demonstrate that it's an offence which carries imprisonment of more than 12 months. The conduct would have been an offence in Hong Kong. The dual criminality is exactly the same. They don't have to match the legal elements, but what they've got to do is show that the conduct, the underlying conduct, is similar to a existing Hong Kong offence. And that, again, there's a schedule of offences. There's 46 offences under the Fugitive Offenders Ordinance. One interesting difference, I think, between your jurisdictions in Hong Kong is it's probably more difficult to be extradited from Hong Kong. The reason is because we don't accept hearsay evidence. And I think in a lot of jurisdictions, they don't adhere to that. So the documents have to be in the form of sworn depositions or affirmations, and they're very strict in relation to this.
And that's
In the United States, they can travel almost exclusively on hearsay. How about in Canada, Leo?
well, unfortunately, we used to have the British system, as Kevin said. The only exception is when it comes to Canadian evidence. That has to be in accordance with Canadian law. But if it's completely U.S. evidence, hearsay is admissible. The only other way out is through our Charter of Rights, because we have a section that prohibits Canadians from being forced out of the country, Section 6. If you can find some kind of a charter breach that would make evidence otherwise inadmissible or as an abusive process, then we can challenge the foreign evidence on that basis, which is why it's so important to try to get the disclosure of whatever you can out of the prosecutors' offices in the U.S. or, for that matter, anywhere else.
Leo, who has the final say-so on an extradition request in Canada? Who has the final word?
The final word is the ministers. So extradition, as we, I think, have learned, is a combination of political and legal. So a request comes into the Minister of Justice. They determine that does the conduct equate to a Canadian crime? Does it have the various sentencing aspects? If so, it goes to the court. The court decides the legal issue. Then it goes back to the minister, where the minister is supposed to think about various aspects that are quote unquote Canadian values. There's a case that actually just came out of about a year ago out of British Columbia, in which an Indigenous person was ordered to be sent to the United States. The courts told the minister to reconsider it in view of Canada's dismal history of treating Aboriginals, and how do Canadians make up for that? In other words, how's he going to be treated in an American jail? So that the unfortunate aspect, however, is that it doesn't apply to anybody else. So for certain types of Canadians, you get an extra level, if you will, of scrutiny by the minister. It's very, very political.
Not surprisingly, the U.S. is very similar. The Secretary of State has the final say-so. The Secretary of State here gets the papers initially, then sends it to the prosecutors. Ultimately, if a decision is made to extradite, it goes back to the Secretary of State in the United States. How about, Kevin, how about in Hong Kong? Who has the final say?
In Hong Kong, it goes to the chief executive.
Is that the governor of Hong Kong?
Yes. Yes, previously called the governor, now called the chief executive. Just one or two other points. It's literally trial by paper, extradition. But if there are witnesses in Hong Kong, they can be received by the magistrate, and evidence can be taken from the witnesses who are actually located in Hong Kong. But a lot of times, say it was a request from the US, there may not be any witnesses who are located in Hong Kong. It would just be based on the depositions. These depositions have to be properly authenticated because they're foreign documents. So if they're not properly authenticated, or there's any issue with the authentication or the depositions themselves, then that can be a route to challenge the extradition as well.
When you say in Hong Kong you can call witnesses, are you saying you're then able to essentially attack the merits of the case upon which the person is being extradited?
Yes. If the witness is located in Hong Kong, That's correct, because the extradition hearing itself takes place before a magistrate in Hong Kong, and it's similar to a committal hearing. It's similar, and in fact, the whole hearings in relation to the sufficiency of evidence, and of course, they're just looking for a prima facie case. They're not looking for anything more than that. But you're still entitled to test the evidence. And if there is a witness in Hong Kong, then that witness can be called.
You see, in the United States, you really can't test it, and it sounds like Canada is pretty much the same way. But before a person can be subject to extradition, but there is a point in time when they can raise a couple of defenses. One of them is torture, that they're afraid that if they are sent somewhere, that they'll be tortured. Can they do that in Canada?
Yes, but that's sometimes it's legal, sometimes it's a political decision. You can raise it in court. We've had that where it turns out if you can show that the evidence against you was founded on torture, you can raise that in the court. On the other hand, if you're afraid that you're going to be tortured by being sent back, it has nothing to do with the evidence. That's a political issue, and the minister will deal with that. It's interesting what Kevin points out about being able to attack the validity of the case. There's a case that went to our Supreme Court dealing with abduction contrary to a family court order. Where
Kevin, can you mute yourself? I think we're getting feedback from you.
Oh, sorry.
That's all right.
Yes.
Okay.
He's much better quiet than... anyway, so there is a built-in defense under Canadian law for abduction where you can allege abuse by the other partner, and that's a defense to abduction. It's not a defense, apparently, in whatever state was seeking the extradition. And our Supreme Court said it's irrelevant. So whatever defenses we might have, they don't apply to the United States. It comes down to the conduct. And that's the only thing that's relevant here. We have a lot of difficulties because of that. We can't cross-examine. We're not allowed to introduce evidence. Whatever we do try to do, the prosecutors, the Crown, acting on behalf of the United States, is always against it. Their position is you've got this quote-unquote certification by the prosecutor. It makes no difference if it's hearsay, and it's very difficult to be able to defeat, save and except, as I said, if you can show some kind of an abuse of process or charter breach, then you can challenge it.
A practical question for you. What country do you do the most international extraditions requests from Canada to where?
To the United States.
That's your most.
They're number one. The others, we get China. We have, and then Europe, Great Britain, the European Union. But there's no question over 80% come from the U.S. and well over 90% end up being sent back. The only, and which comes in again, as we're all, for those of us who are criminal lawyers, whether you want to call it plea bargaining or negotiating, but sometimes the best thing to do is to reach out to the prosecutors. When we used to send people for capital punishment, we don't anymore, but my very first case involved two individuals who were facing the death penalty in North or South Carolina. And the deal that I worked out was that they would waive extradition if they dropped the death penalty. Other times, you waive extradition in agreement for bail, or you waive extradition because, in fact, you've worked it out. So we've worked out sentences, and we've worked out that they can serve their sentence in Canada. So, you know, extradition, I mean, it's not just sending the person there. Can you work something out as to how they're going to be treated there? Can you work something out to have them come back to Canada, serve the sentence, and get released in a hell of a lot quicker time than in the US?
Don't they have to be Canadian citizens to serve their sentence in Canada?
Canadian citizen or Canadian resident?
Got it. Got
Yeah.
it. Kevin, and how about you? Where do you see the most extradition requests in Hong Kong? From what country?
Well, I looked at statistics, but I couldn't really find a division of countries, but I would imagine it's the USA. Statistics-wise, all I could find was that between December 2018 and from 97 to 2018, there was 109 fugitive surrenders. And I think the US would probably be the most. The most I've done is in relation to the US. Back to what you were saying about torture claimants. In Hong Kong, there's a separate system for people who are torture claimants. It's under the immigration ordinance, so it's a completely different system. The court of committal has got no role to play. In fact, what people don't know, there's probably about 15,000 torture claimants present in Hong Kong, who are in Hong Kong and waiting to get to court in relation to their claim. A lot of them are just given an allowance for food and for living expenses, but there's quite a lot. I think it's something people don't know. There's about 15,000. Yeah.
Wow. In United States, it's no surprise that the country that we most request from is Canada. There have been some other countries that have come close, like for a while, Colombia, that's dropped off. For a while, Panama was another one. But because I guess we're so close, Canada's in there is at the top. And then the second and third changes off. Mexico is another one that's very high. And I guess it has to do with our common borders.
Right, right.
Okay, there's a question that somebody asked. What is the status of Julian Assange's case, if anyone knows? Do either of you know the status?
I believe he's still, he just finished serving his sentence for skipping bail, but he's still in the UK. And the last I saw, and it's strictly on media reports, was that Sweden has now reactivated its request for extradition.
That was a rape case, right? That was a rape case in Sweden?
Well, it was, and they've now said that it's a different charge. So I don't know what the British courts will do, because the Americans still want him, as far as I know. And of course, another famous person that they want is Snowden. He's hiding out in Russia, which highlights, if you will, the political side of at least some of the infamous extradition requests, as opposed to the more mundane drugs and frauds.
Interestingly, Trump in the last week or so tweeted that somebody talked to him about pardoning Snowden, and he was going to look into it. So that furthers the political side of it.
Exactly.
We read that.
Another question, I'll toss this one to you, Kevin. With proper evidence and going through the proper channels, how quickly can an extradition take place, or is it case by case?
It's very much case by case, but it can be quite a torturous process and length, because once you've gone through the extradition process, there's several avenues you can challenge. For example, you can apply for habeas corpus, and you can then petition the chief executive. So it can be quite a torturous experience. I remember there was a case of Osmond who he fled. He was Malaysian. He fled to the UK, and he ended up being in the UK, fighting extradition for a period of 7 years. And when he came back, I think he only did a 6-month sentence when he came back. So it just shows you the length of time which these things can be stretched. But the ones I've been involved with, I've been involved in a few, and generally speaking, the drugs cases. And if a person is willing to go back to the US and they've got legal counsel in the US, they can usually cut some form of deal to accept voluntary extradition.
Most extradition treaties have time limits in them. For example, if a country doesn't have the formal paperwork done yet, they can have what's called a provisional arrest. And a provisional arrest is just, we found out where the guy is, please grab him, and then we'll send the paperwork later. And most of the treaties give time limits of between 30 and 90 days for that paperwork to arrive. And then after that, the hearing is scheduled pursuant to the treaty. That also is generally prescribed by the treaty. However, that can be extended by the parties. And then after the extradition is granted, which usually is, then there's a time prescribed by when the requesting country has to pick up the person. So there are time limits in the treaties, and every treaty has different time limits, although they generally fall within that 30 to 120 day time frame to do things. But the practical effect is that it's case by case, depends on how hard it's fought. And I've been involved in extraditions where the fastest we could get somebody out of the, to go back was like 90 days, because even if they waive, there's a lot of paperwork that needs to be done. And then if they fight it, we've seen them delayed a couple of years or more. Another question, do you know the success rate for a person to avoid extradition by filing a U.S. asylum claim?
In Canada, I don't know about the U.S., but that doesn't stop an extradition. Again, it depends. If you're going to be extradited to some country that has a terrible human rights record, and the reason that you're in Canada is asylum from that country, yes, then the minister the Minister of Justice, not the Minister of Immigration, the Minister of Justice won't extradite you. And so you can continue with your asylum. But just filing I have a client who's wanted in the US. He's Tibetan origin, which would mean if he's extradited to the US and convicted, he'd be sent to China. And there's a history of torture. But that's not stopping the extradition from Canada to the US, because that's considered an American issue if he's convicted.
I actually have had an extradition where the client was also seeking asylum, and basically what happens is they travel on parallel tracks. It does, as Leo said, in Canada, in the United States, it does not stop the extradition proceedings in court. But what happens is, after the extradition proceedings are completed and a certificate of eligibility to be extradited or a recommendation for extradition, the Department of State sees the asylum request and usually will postpone any actual execution of extradition until the asylum request is adjudicated. So it can delay it, but it's on the political side, not on the legal side. That's how that works.
Well, we just had a very interesting ruling from our courts just 2 weeks ago. Canada and the U.S. have what's called a safe state treaty, which means that if you're seeking asylum and you happen to hit the U.S. first, you have to apply there. You can't come to Canada and through the U.S. and apply. So there was a challenge to that, saying that the U.S. is no longer a safe state, and it was successful. So maybe things will change now on the extradition side.
Not safe because of the pandemic?
No, not safe because of the politics.
Ah, okay. Because that dovetails in with a question that Arnie just asked, which is, how has the pandemic come up as a basis to oppose extradition? I haven't seen that yet in the United States. It's too soon for it to really factor in. But listen, we're certainly using it in the United States to try and get people out of jail, saying that the jails are unsafe. But I haven't seen it in any extradition cases yet. Have either of you two?
Well, I've seen it in one case where there was an attempt to show how bad the conditions were in the U.S., and the Americans filed material saying it's no worse than it would be out of jail. So the court said, well, tough. It hasn't stopped an extradition, no.
Kevin, have you seen anything where they've tried to use the pandemic anywhere yet?
Not experienced it in relation to extradition, but I had a case where the Korean guy was arrested in Hong Kong for an offense. And he said that the reason he was in Hong Kong was because of the number of COVID cases in Korea. And in fact, Hong Kong's had quite a low number, but we are on now the third wave. So we're getting double-digit numbers, 60 cases a day, and it's gone from zero back up to, it went from zero back up to 100 cases a day, and now it's down 40 to 60. But this guy just didn't want to go back to Korea because it was very serious at that point, but not in relation to extradition.
Okay, you have a client who is in your country. His extradition has been requested. The paperwork for the extradition doesn't get there within the time limit. What happens in that case, Leo?
Well, if you can catch it before the end of the expiry, so let's say 90 days, if the Americans or the Canadians realize that it's being delayed, they can ask the court to extend the time, and the court will. It's very difficult. I am, in fact, challenging it in two cases where I'm saying that the materials didn't come in within the 90 days, and there was never a request by the Americans or the Crown to extend the time, and therefore there's no jurisdiction. We'll see what happens. But for the most part, delays are not really an excuse or a ground to avoid extradition.
Can you at least get him bail? Can you at least get him bail if the paperwork's late?
Oh yeah, you can. Well, actually, no, because he should be released. If the paperwork doesn't come in on time, he must be released under the treaty. But they can always rearrest him. The problem with our Extradition Act is that it allows for basically rearrests. It allows for appeals. So prosecutors, if there is a successful defense of an extradition, our prosecutors have a right of appeal, and it can go up and down the ladder several times depending on who wins what.
All right, there's a question from Lloyd Hoffer, it looks like for Leo. It says, Leo, I think that the recent case was based on the specifics of how the person attempting to claim in Canada would be treated on return to the U.S. having attempted to cross into Canada. Am I correct? In other words, not a broader comment on the U.S. political environment, just on the treatment of the claimant in the U.S. system.
There were several claimants, and there was also several organizations that joined into that case. So I think it's a little broader than just the one specific individual. But yes, the way they were treated, the politics was part of it. The way they were treated was there. But the overall ruling is actually quite extraordinary. I'm not sure, and maybe Lloyd, I wasn't keeping track of it, whether the Crown has appealed. And if they do, this will be an interesting case ultimately for our Supreme Court.
Larry from Chicago. Kevin, this question is for both you and Leo, so why don't you tackle it first? If extradition fails, does Canada or Hong Kong allow for a criminal trial without the defendant present? I assume that means that the case, that the crime for the extradition would also have to be a crime in Hong Kong or Canada as well.
No, they won't do a trial without any defendant present. No. If it's a normal criminal trial and the defendant absconds, they can continue with the trial in his absence, but not before it's occurred. not in Hong Kong.
Right, no.
Are there any circumstances in Hong Kong where you can have a criminal trial with a defendant in absentia?
In the magistrates, there's several offences where a solicitor can turn up instead of the client, but they're normally, summons offences.
Minor
not,
offenses.
Charges. Yeah, minor offences. So the solicitor can turn up and just enter a plea. But generally speaking, if it's a charge, then the person has to attend.
What about in Canada, Leo?
Yeah, in our criminal code, at a trial, a judge can excuse you, or if the trial started and you abscond, it can continue, but you can't have an ex parte trial. However, you do bring up another interesting point, because on the political side, one of the issues that the minister has to consider, so the court orders you extradited, it goes back to the Minister of Justice. One of the things that they have to consider is what's called the Catroni factor. Catroni was sent to the US. He was a noted criminal in Canada. And this is where Section 6 of our charter comes in, which is it in fact more expedient to put you on trial in Canada? And if it is, then they can't extradite you. They have to do the trial there, which allows us another bargaining chip. Sometimes we can get the Americans to agree, all right, if you plead guilty in Canada to a related Canadian offense, and we have some input about sentence or whatever, you can do it. And if in fact you do plead guilty, I once did a drug case where my client was charged on both sides of the Canadian-US border, and he was pleading guilty to the Canadian offense, and we read in the facts of what he was facing in the US, and the judge therefore increased the sentence from just what the Canadian offense would have been. He added on another couple of years, which is a hell of a lot less than my client would have received in the US. And so he was sentenced, and then you can't be extradited because the offense is dealt with in Canada. So it can sometimes occur that you don't necessarily have a trial. Usually it works out as a plea, where you're going to plead in Canada, and they will then drop the extradition.
So, Kevin, Leo just gave an example of being able to negotiate to avoid extradition by contacting the requesting country. What types of things can you negotiate with the requesting country that you've had?
In Hong Kong, it's quite old-fashioned. Usually, if there is an extradition request, there's not much chance to negotiate. The Department of Justice controls it. And the Department of Justice will really not have much contact with you. They will issue the arrest warrant and arrest the person. I think there's obviously a fear that someone may abscond. And again, as I said, Hong Kong has got plenty of water around the island, and it's not that difficult to do that. So generally speaking, we don't get much forewarning. If there is an arrest to be done, it's usually effected. And then, as I said before, it's a very stringent and rigorous process. So if they won't issue the warrant if they're not serious about doing the actual extradition.
I agree. I mean, I don't want to make it seem as if we're totally open. We're not. If they want to extradite you, it's difficult, but there is availability, and because of the commonality between Canada and the US, there is availability to at least contact district attorney, US attorney, whatever, and try to deal with them directly. And if you can reach an agreement, my experience has been that the bureaucrats at the ministries on both sides of the border, frankly, don't care and will agree to that.
Well, when you say reach agreement, what are you trying to agree on that to prevent an extradition? What do you agree on?
Well, as I said, sometimes you're agreeing that you'll waive extradition for bail.
Okay, well, all right, but
or
that's an
for
easy one, but
sentencing.
they're still going though, right? They're still
Oh
going.
yeah, you're still going. Or you do it the other way, as I said with the drug case, where we did it, and I'm trying to do it right now with a case involving, unfortunately, child pornography that my client was involved with.
Allegedly.
So, no, he was. It's a legal issue. It's not a factual issue. I think one of the other aspects, and I had it down here, is Interpol. There are many times, and of course, when we talk about international criminal law, it's not just extradition, it's not just mutual legal assistance, it's not just cross-border sort of drug dealing or whatever. You also have Interpol. And what a lot of people, I have clients who are wanted by other countries that Canada will not extradite them because they're not, shall we say, rule of law countries. But you have to caution the client. You step outside Canada, you cross the border, and you never know what's going to happen in the other country. And there are times it works the reverse. I had a client, he was in Australia, he flew to Abu Dhabi. He was held because there's a warrant from Canada, but Canada didn't want to extradite him. So Abu Dhabi let him go. He flew to Istanbul. Istanbul arrested him. Again, he wasn't brought back. But you do have that very, very real international issue of being arrested and held in local jails because of Interpol, forgetting about extradition.
The Interpol arrest warrant is essentially known as a red notice.
Right.
Does Hong Kong honor red notices, Kevin?
Yes, it does. I mean, a red notice basically means that they're seeking the location of the arrested person with a view to extradition. But there are occasions where I think you have to look at it in practical terms. There's some countries that just don't do the extradition because maybe it's just a very expensive process. I've had, and sometimes it's just that the country who wants to extradite, maybe there's a quagmire of applications, law, objections. Because I've had an Indian guy in Hong Kong who's contacted me several times to ask about extradition, and there's a red notice for him. He's there. I've checked, and actually nothing's being done. He's a Hong Kong permanent resident. India has a red notice, and they haven't done a thing. So it really depends. I think it's financial as well sometimes. I mean, we get very few extradition requests from the UK, and sometimes I just think it's the sheer cost, the need sometimes to send officers out. It's not an inexpensive activity, and I think it has to be very serious before people even consider it sometimes, in a practical sense.
Right, and that's of course our problem, because with the common border, it's the easiest thing to take a Canadian anywhere and just turn them over.
Leo, in your situation, you said there was a red notice for a client and he got arrested in successive countries, and Canada, and each time said they weren't going to extradite him. Right. Isn't there a way to get the red notice removed once Canada says they're not going to extradite him?
Yes, there is provision under the charter, if you will, of Interpol to have it removed, but it's not necessarily just on the basis that Canada thought that it wasn't worth the expense of going to Abu Dhabi or Australia to bring him back, because there's no doubt in my mind that if he shows up on this side of the water, he'd be extradited. But you can apply to have the red notice removed. It's difficult, and you have to show that essentially it was an ulterior motive that put your name on the red notice in the first place. We've got 2 applications that we're in the midst of doing, and it's very slow. Never mind COVID. I mean, even before COVID, it took a long time because, of course, the country that put you on the red notice gets notification, and they can argue against it.
Okay, the Lutzkers have another question.
They're only valid. Actually, the notices are only valid 5 years. They have a limitation as well.
Yeah.
Okay, the Lutzkers' question is, if there is a double offense situation, crime in both countries, and a resolution in one country, does that raise a question of double jeopardy if the other country wants to prosecute? Is that a good defense?
Yeah. If it's the extradition in Canada, the act goes on conduct. So if you can call it something else, but if the conduct is the equivalent and you've been convicted of that conduct in Canada, they won't extradite you to face the same conduct-based charge somewhere else.
Okay.
Same in Hong Kong. It's double jeopardy.
Yeah. Right.
Well, in the United States, I've seen cases where somebody's prosecuted in another country for a similar offense. For example, it's happened a lot with Colombians, where the Colombian government will prosecute somebody for a drug offense, and then the United States will still extradite them for a drug offense having committed it in the United States, even though it may encompass the same time period, under the theory that whatever you did in Colombia, you did in Colombia, but you brought the drugs or had responsible for bringing the drugs to our country, and they'll prosecute them as if they had not been prosecuted in Colombia. So I think my guess would be that Canada would do the same thing in that kind of a situation.
We wouldn't extradite.
Would not extradite.
No, not for the same conduct. You can call it whatever you want, but if it's the same conduct, then I would be surprised if they'd be extradited.
All right. I see that our time is, we're getting close to the end. If anybody has any other questions, we can field them. If not, I think this is a good place to stop. I think Kevin and Leo, you're experts in your fields. You're preeminent lawyers in your countries, and you've really helped us, get a handle on international extradition. And I want to thank you both for agreeing to participate in this panel.
My pleasure. Kevin's pleasure too.
My pleasure.
Very good. Thank you.
Ours too. So thanks. Good job.
Everybody stay safe.
Very interesting.
Thank you.
Bye-bye.
Bye, everybody.
Bye-bye. Thanks.
Stay
Good
safe.
job,
Take
Sam.
care.
Good job.
Thank you.
Thank
Bye-bye.
you.